Okay, welcome friends. Today I am going to speak about one judgment of country Colonizers Pvt Ltd decided by the RERA Punjab Authority dated 23rd of June 2022. These are three complaints that have been clubbed together and decided simultaneously. Now let us have the relevant paras. The transfer of the cases have been done in view of the latest Supreme Court judgment, New Tech Promoters and Developers. That is why the cases for refund are now being decided by the authority. Now further coming to the position of law, as far as the possession has been offered to the allottees, complainant in this case, and the precedents wherein authority has held once the possession has been offered, the refund is not made out. There are three judgments quoted: Mahima Sharma versus Country Colonizers, Alka Masta versus Sushma Biltek, and Sumit Airi versus Sushma Biltek. So the view of the court has already been laid out here. Now the factual matrix, as you can see, it is there in the tabular format. 2012 is the date of agreement. Date of possession comes to 2015 and possession is offered in 2019, and date of filing complaint is 2021. So considerable delay has been there in filing of the complaint. Now let us have the averments. What has been pleaded in this case? So when the possession was offered, the respondent builder was having the occupancy certificates, and the complainants did not exercise the option of seeking refund within time. That is the plea of respondent builder. So they have waited quite a long period of time and then they have filed the complaint. So the delay in filing of the complaint is fatal to the case of complainant. Also previously, these complainants have filed the complaint before State Commission Punjab, but due to some or the other reason they have withdrawn it. So this fact was brought to the authority and the complainants didn't give a satisfactory reply. Now further, the arguments are quoted in para number 6. Now let us see what arguments are being given. So first one was the delay, that after having the possession offered, there is a good amount of delay in which the complainants are liable for default, and also that section 1910 of the RERA Act cast upon duty allottee to take the possession within 2 months of issuance of occupancy certificate. So the authority has held complainants are in default of this provision. Therefore, the refund cannot be granted in this case. A peculiar case is case number 3, that is the third complaint, wherein the possession was made subsequently, because the complaint was filed in 2021, March 1st, and on 31st March the possession was given. So technically the authority held that the above precedents will not apply, but following a Supreme Court judgment of IREO Grace Realtek versus Abhishek Khanna, where it was held once the occupancy certificate has been granted, on this principle the possession ought not to be given, the refund ought not to be given to the complainant. Further, one appeal of Real Estate Appellate Tribunal Punjab has also been quoted, wherein the same principle was held, that refund in these circumstances are not warranted. Therefore, the Limitation Act won't apply to these proceedings. Now, yet, after giving a considerable period of time, let us say 3 years is now considered to be a reasonable time within which the builder promoter are to give the possession to the builders. But yes, there was a delay. The authority has held it in their judgment. That delay is there. But now allowing the refund once the possession has been offered is the best situation avoided. There will be undue advantage to the complainant in this case, and that's not what the authority want to held in this case. So the view has been made the same here. So all three complaints are treated in the same manner, and hence the refund is now refused to all three complaints. So in the foregoing paras, the authority has held that refund has been denied in other two cases, and allowing it here would be an exception that does not have adequate justification. So to the authority's mind, this was not the case, and therefore the refund in all these three complaints was accordingly dismissed. So this is a good judgment, which I must say, and people who are looking out for their reliefs before the authority I must say they should act within time. Otherwise, their case gets weaker and they have very less to defend in the courts. So make up your mind and always take action, promptly action, whenever there is a default by the builder. So hope this judgment helps, and do subscribe to my channel for more legal updates or judgment digest, and do subscribe to my channel. Thanks for watching.